Thank you so much for joining us today for this very exciting panel. We're proud to present today's community forum with Disability Rights of Texas. There will be CEUs for LPCs, LCSWs, LMFTs, and the Texas Board of Addiction Professionals. Please sign in using the link in the chat if you are seeking CEUs and take the evaluation at the end of the forum. Your CEU certificate will be emailed to you. We are recording today's forum and streaming it on Facebook today. So before we get started with the panel, I'd like to provide some history on mental health centers. Prior to the 1960s, people with mental illness and IDD diagnosis often lived their entire lives in institutions in inhumane conditions. They were considered inferior and oftentimes considered dangerous and were shut away from society. President John F. Kennedy's sister, Rosemary, had developmental disabilities. In her late teens, she started displaying erratic behavior and angry outbursts. And to cure Rosemary of these behaviors, a doctor performed a prefrontal lobe lobotomy, when she was 23. The procedure left Rosemary unable to walk, care for herself, or communicate her needs. She spent the rest of her life in institutions. In 1958, JFK saw his sister Rosemary for the first time in 17 years. And several years later, JFK introduced the Community Mental Health Act of 1963. The goal of the legislation was to provide community-based voluntary care as an alternative to institutionalization. Federal grants were provided to states to establish local mental health centers like Integral Care, and we were established in 1967. Now, on to the panel. With that background, I'm honored to welcome our panel for today's discussion on the rights of people with behavioral health needs in Texas. And I'm going to introduce our panelists. And with each of you, wave when I introduce you. Beth Mitchell is the supervising attorney, litigation coordinator with Disability Rights of Texas. She has experience representing individuals with mental illness and obtaining community services and advocating for their rights within mental health, juvenile justice, jail, and prison facilities. Her work focuses on system change, impact litigation, administrative procedures, policy rulemaking, and educating lawmakers. She recently began the residential child care monitoring team at Disability Rights of Texas, assisting with monitoring the state's compliance with the MD versus Abbott court order regarding the care and treatment of Texas foster youth. Beth also serves as one of the Texas Judicial Commissioners on mental health. Amy Pierce serves as the Peer Services Field Liaison at Via Hope. Previously, she was the CEO of Resiliency Unleashed, an international training and consulting company focused on development and implementation of peer services. She started the first peer support program in Texas State Hospital System, was a peer support worker in a community mental health agency, and served as the program coordinator for transitional peer residential housing. She was also chair of the Protective and Advocacy for Individuals with Mental Illness Council in Texas and on the U.S. National Disability Rights Board. Dr. Ziyad Nuwayhid has been with Integral Care as a staff physician since 2018 and currently serves as a psychiatrist for the Travis County Correctional System. He attended the University of Chicago as an undergraduate and graduated from the University of Texas Health Science Center at San Antonio School of Medicine in 2012. Dr. Nuwayhid subsequently completed a residency in general psychiatry in San Antonio in 2016 and a fellowship in forensic psychiatry at the University of California at Irvine in 2017. We'll start with the panel discussion and move to audience questions for the last 10 to 15 minutes. Please type any questions you have in the Q&A box at the bottom of your screen, and we'll get to as many of those as we can. In case we run out of time, and we usually do, please include your email so that we can follow up with you after the forum. Okay, now to the questions. So the first question is, whether you're a patient, a client, a family member, or a caregiver, it's critical to know the rights of people living with behavioral health needs. Beth, what rights do people living with behavioral health needs have in Texas?
So I think, all of the rights that all of us have come from the Constitution, right? Like that's basically where most of our inalienable rights come from. And that's true of people with mental illness. They don't lose those rights just because they have a mental illness. And one of those biggest rights for people with mental illness is the right to liberty. And what the Constitution and case law has said is that a person's right to liberty cannot be restricted or restrained without due process, which means there has to be a hearing. And then also, only if the individual has a mental illness and are dangerous, right? Or they have an intellectual disability and can't survive in the community on their own or with the help of others. That right to liberty also provides individuals with the right to refuse treatment and the right to refuse medication. There's been several Supreme Court case law that talks about an individual's right to choose what to do with their own bodies, right? And that is part of that right. And there have been cases explicitly related to psychotropic medications and the right of people to be able to choose those when to receive those medications. So those are some of those general constitutional rights that I think you have generally when you're in the community. I think more specifically related to local mental health authority services, those rights are more rule related than they are coming from the Constitution. But there are rules that require local authorities to provide crisis screening and assessments 24 hours a day, every day of the year, and that those assessments can't be delegated to law enforcement, that those screenings should happen face-to-face within an hour after an individual presents to a provider if they're in crisis, and that if the person requires emergency care services, that the QMHP should then look for a physician who can assess the person within 12 hours to determine if there's any additional services that are necessary. So those are some of the general rights. The other is for Medicaid individuals, because in the community, people with Medicaid have more rights than people who don't have Medicaid. Mm-hmm. And so for Medicaid individuals, if you are receiving, if you've gotten an answer from a local authority and that answer says these are all the necessary psychiatric and rehabilitative services that you have, you are required to receive those and not be placed on a wait list and not be given only part of those services, but given all of those necessary services. Again, that's only if you're a Medicaid eligible individual. That is not true if you are not. One of some of the other general rights that I would talk about are the right to accept some services but decline others. So you might decide you want to accept housing from a local authority, but you don't want to go to rehab services. The local authority can't say you can't get anything unless you take everything. You can accept certain services and decline others. Again, that kind of goes back to your right to accept or decline services. So I think those are some of the big general rights that I would say, that people have.
Amy, would you like to weigh in on that question from your experience?
Yeah, I sure would. Thank you. And thanks for sharing all that, Beth. I think one of the things as a person with lived experience and just reflecting on my own journey is it wasn't until I started working in the rights department at the state hospital that I actually understood the rights that I did have. Right. I didn't know that, you couldn't keep somebody in restraints for over 24 hours. Right. I didn't know that I could say no to this medication, and felt that at that point in time, how it was presented, that that was my only option, to take some really heavy duty antipsychotics that left me just pull a drill on my, shirt. I didn't know these things. That didn't mean I didn't get a booklet, but I got that booklet when I usually was in the place of a really extreme crisis, and who knows where it went. And having the opportunity to work, not just in the client's rights space, but as a peer supporter, one of the things that I have found is being able to share those experiences with others in a way for their understanding of their rights has been an incredible healing experience, but it's also been a way in which I've seen people really being able to step into their own selves and really look at what is best for me, right? Because sometimes we may say no, and it's not a no, it's a that doesn't work, and I don't know what works, but I can't do it, right? But I don't have the language to say it. I didn't know I could not sign the paper about ECTs, right? Or not, change my medications when I wanted to go work at the state hospital. That, they were gonna have my medications, or I was gonna lose my ACT team services. So these things happen. They've happened for me in a lot of different ways, and it's only through the ability to reflect that I've been able to see the parts and the places in my own life where those rights, were violated.
And Amy, and I don't mean to take over your role of asking questions, Louise, but but can you talk about the empowerment that gave you as part of that, as part of knowing those rights, and how that helped in your mental health well-being as well?
Yeah, it wasn't until my last hospitalization that I was working with a psychologist, and we were doing some different things, and we're starting to talk about like speaking up in that self-advocacy. And I had a nurse who showed me about a notebook to write things down, because I go into the treatment team and would just sit there and forget things, right? And my needs wouldn't get met. And I can still remember to this day the first time I went into the treatment team and like sat there and read from my book. And they're like, okay. And it was like the most incredible experience. And as a peer support specialist, it's been a place where like I get to see people's eyes shift, their life change when they start finding their voice. And most of it's just like walking alongside them, because you don't know what you don't know. And those experiences can be really terrifying, right? You can't leave. You've got these papers. Where do these papers go? You must do this. If you don't do this, we're going to take to court. And it can be overwhelming. And it's one of the reasons why when I started the peer program as peer specialist, we would go out 3 to 4 days after someone came in and just kind of talk with them and like share different things about what to expect, and especially persons who had never been there. And I continued that in the community when we did that. And it's an amazing thing, because when you're able to get your own needs met and actually start learning, or for me, when I was able to get my own needs met and really start getting that I know what I needed, my life changed.
Thank you so much for that, Amy. Not only relating to your own experience, but also demonstrating to others how empowering it can be to really take control of your life. This next question is, and we've talked some about this, many of these rights seem to revolve around the idea of consent to care. Beth, how can these rights be limited by the law? And then after Beth answers that question, Dr. Nuwayhid, if you would weigh in on that as well.
Yes, I think there's several ways that, these rights can be limited, right? So a person can be institutionalized against their will if they meet certain criteria. And as I indicated before, the Supreme Court has talked about what that criteria is in terms of dangerousness and, well, having a mental illness, and because of that mental illness, you are dangerous. And I will let Dr. Nuwayhid talk about what that actually means, usually by a clinician, and how a court potentially interprets some of that. So unless you're a parent of a minor child, the only way a person can get institutionalized is if it is involuntary, right? Or they voluntarily consent, right? So otherwise they have to go through court, and a court has to order them in. If you're a parent of a minor child, then that parent of a minor child is the one who gets to make that decision. And actually the facilities can't make that decision for them. It is the parent who ultimately gets that decision. So we have seen, in the reverse of, I think, what a lot of people are used to, but we have seen a lot of times where a parent does not want their minor child in a institution. They have services in the community that they're willing to provide for them, and the institution wants to keep them. A parent of a minor child has the absolute right to take them out. But otherwise, right, it would be through emergency detention in court, ordered inpatient services. A guardian does not have the right to voluntarily admit an individual to an institution. A guardian can, if they feel they can transport a person, they can transport a person to a facility and provide an application to that facility and to the court that gave them that granted the guardianship papers. And then the person would be under that emergency detention until the physician conducted their evaluation within 12 hours. So that's the only way a guardian can kind of voluntarily. It's not, because there still has to be an application, but if they can actually transport the person themselves, they do have the ability to do that for a little bit. And as we're talking, an emergency detention only lasts for 48 hours. And all of these things are limited, right? So it only lasts for 48 hours. And additionally, within 12 hours, a physician has to actually review the individual to determine if they're actually meeting criteria to remain for even that 48 hours. During that time, a person cannot be medicated against their will unless it's an emergency situation. The only time that a court can order a person to be medicated against their will is when they get to the point of receiving temporary or extended inpatient mental health services. And that medication only lasts for the term of the commitment. Even on an outpatient commitment, medications cannot be forced. They can be recommended, but they cannot be forced. On outpatient commitments, if a person stops taking their medication, that is not a reason that a outpatient commitment would end and a person would go inpatient. Again, the only way that happens is if the individual then becomes a danger to themselves or others, and then they can bring the person back in for an inpatient commitment. Another place in terms of jails, a lot of times we get calls of parents who are indicating that their loved ones are not receiving medications while they're in jail. Well, jails are the same thing. That medications can't be forced while a person is in jail. There's only two ways that they can be forced when they're in jail. Is after the person has been found incompetent to stand trial and they've yet to be transported to an inpatient facility. There can be a hearing and the person can then be medicated during that period of time, or after they've received care at a state hospital and they're coming back to jail, they can be medicated, but only for about 180 days at the most. That's the longest they can be medicated once they come back. It's either that or when the charges are dismissed or convicted, it's the earliest of those 3 days. So even though a parent may want, or a family member may want somebody to be medicated while they're in jail, that's generally, again, not going to happen unless they consent. And some of that, and I am not a criminal defense attorney, but a lot of that's discussions between the individual and the criminal defense attorney as well, because, depending on the medications, it may not assist in their defense. Some other ways that in terms of medication is there's medical power of attorney, or a person can get a guardianship, right? So if you get a guardianship, then you can make decisions over whether or not your ward is medicated. But just so you know, I mean, you can say, yes, they have to be medicated, but nobody's still going to force them and hold them down to shoot them up with medications, right? Or hold their mouth and drop water down their mouth and hold their nose so the med is swallowed, right? So even though at that point you have the ability, guardian may have the ability to consent to the medication on behalf of the person, in terms of actually being able to force the person to take the medication may be a little bit more difficult. And so one of the things, and I think Amy's probably going to talk about this a little bit later, is it's a good reason to work on a psychiatric advance directive with individuals. And I think, I think a little later on, Amy may be talking about this, but it is a great form for families and loved ones and clients or individuals, who have behavioral health issues to get together and sit down and talk through what treatment does work for them, or what other services are they willing to accept and help when they aren't doing so well. And I think that's usually a better approach, because as Amy had discussed earlier, right, once you get people accepting and involved in their own care, usually that is more helpful than trying to force any type of care or treatment.
That's an excellent point about the advance directives, Beth. Now, Dr. Nuwayhid, would you like to weigh in on this question concerning what it looks like from your perspective?
Yes. So in terms of how, people might get to this stage of care, is the emergency detention that Beth was talking about. That's typically initiated by law enforcement, who is responding to a call from family or loved ones, or even just some situation that has occurred where a potentially mentally ill person is involved in some incident. And then, having filled out that paperwork, they need to be evaluated, and part of that evaluation is a physician evaluation. And when I do those, the biggest criteria, of course, I'm looking at, as Beth mentioned, is the dangerousness, either to themselves or to others. Now that can be, something very obvious, like there's been actual physical violence, or there has been a suicide attempt, or it's possible that person, due to their illness, is so deconditioned and in such bad shape that they've done something that could potentially harm themselves. They're walking in traffic. They are not attending to immediate medical needs if they have some kind of acute illness or acute injury that needs to be tended to. If they're engaging in behavior that's not directed at someone necessarily, but could become dangerous. They've managed to get a firearm, they're firing in the air, something like that. They're playing with knives. And if they meet those criteria, then I file usually what's called an order of protective custody. And that is to get them a bed at an inpatient treatment facility where further treatment can occur. And should there is a probable cause hearing that occurs through the court to make sure that is correct, that they meet that criteria. Typically, the court will grant that if it's clear that those criteria are met. And it's unusual that an order of protective custody or the application for one would be filed if that wasn't pretty clear. Obviously, there are exceptions, but it should be something that the court can clearly see there's something going on that needs to be addressed. And then once that bed is obtained and the patient reaches an inpatient treatment facility, as Beth mentioned, they can still refuse. They don't have to interact with the staff. They don't have to engage in any kind of treatment. Certainly, they can't have medications forced on them. But they will meet with with nursing, with a physician with clinical care staff that, when they're at their best, should try to engage them, see if they can offer some kind of help. The ability to accept that help can be affected by how badly that person is suffering at that time, other circumstances that may be involved, whatever kind of medical issues they have. Sometimes they're psychotic, sometimes they are very impaired in their thinking about what's going on, very paranoid. Sometimes they can be manic, as in bipolar disorder. There's just a total inability to sort of focus on what's going on. Now, if it is the case that that person is not able or willing to accept treatment, and the staff feels again that there's a clear need for that treatment, there's an application for, as Beth mentioned, for temporary court-ordered mental health services. And as part of that, to extend their stay in the inpatient facility, there's also a compelled medication portion of that application, where the physician determines what medications would be appropriate to treat this illness, and that if it goes untreated, that there's also the danger of harming themselves or harming others, or this being severely decompensated in such bad shape that they can't take care of themselves. That sort of a thing. And then there's a court hearing on that, both for the temporary services and the medication hearing as well. And then beyond a certain point, if you want to extend those services, you have to go through another hearing. And that's sort of how it goes. Briefly, as Beth mentioned, in jail, because a jail is not a healthcare facility, although often jails do provide a lot of healthcare. They're certainly not a psychiatric care facility in the way that typically hospitals or freestanding psychiatric facilities are. So they have to really be found incompetent to stand trial, and that commitment, which is a forensic commitment instead of a civil commitment, is the equivalent of a temporary commitment for services. And this is, once you're found incompetent, you're ordered to go to a state hospital, and which state hospital sort of depends on different factors. But frequently, because of the need for many patients to get that care at that level, and unfortunately due to the COVID-19 pandemic, that has affected the ability of hospitals to operate at the same level of efficiency. Patients do wait in jail to go to these facilities. So typically, I then do another assessment of whether they need medication, and how that would help them. And then again, go to court for a hearing about compelled medication, just as I would if they were in a sort of regular hospital instead. And the court is usually very engaged. Patients have their own attorney who is advocating for them, and we talk about, well, is this really necessary? Is it the least restrictive thing we can do? We want to be respectful of their autonomy, their ability to make decisions for themselves, and we really want to say this is actually an extreme case, and we're proceeding in restricting this person's liberty because we feel it's absolutely necessary in these circumstances, and that it will be beneficial for them, not detrimental to them.
Thank you.
Yes.
Oh, I'm sorry. You weren't finished. Go ahead.
No, and we have to be able to, clearly demonstrate that to the court.
Okay, thank you. You've mentioned some reasons that people might refuse medication, might refuse treatment, um, depending on where they are, how they're feeling. Um, I know Amy has some things she'd like to say regarding um, how one might feel by declining services.
First I'll speak from my own lived experience. And um, I shared briefly about that time when I went to my ACT team, and I was on the ACT team, which is the highest level of care. And I wanted to go get a part-time job, and it was at the state hospital, and I'd figured it out. I knew what I wanted, and the team itself came together in a way that was making the point that I was getting unwell, right? And instead of like in that moment, all I felt my options was to leave the team, right? And so I stopped services there after I got that part-time job. And part of that goes to, there's a fear that runs, and how it gets perpetrated is different depending upon the organization, I think, and as well as circumstances. But I know people, when I worked in peer support in the LMHAs, who would go to the doctor, they would do med management, and they would throw the medications away because they wanted therapy and peer support, but they were afraid, and they were told that they had to have med management as well, right? And so because of that fear, they would go through and like have their own internal dialogue going on about being I totally lost the word, but about being not honest. It's not the word, but we're going to go with that. How's that?
Mm-hmm.
Which was impactful, right? And then you start thinking about in the state hospital system, which I know we're talking community, but you talk about not wanting to take a medication, and the first thing that tends to happen is we'll go get a court order, right? Mm-hmm. And so there's a fear of, I can't say, or I can't have a conversation about the reasoning why this doesn't work. And it also, I think, this is just my opinion for myself, also happened is you also get so used to people not listening, right? There's a point where many people stop asking. And I think that because individuals are not readily informed of their rights on a consistent basis, there's not that understanding of, you can do this, it's okay, right? And it's okay to ask or say this doesn't work. And you're not at risk for losing your services. And unfortunately, I think people have had the experience where that's not been the case, or seen people who've had experience where that's not been the case. And
Amy, I also think, that people may be willing to do the peer review services only at first, but once you do that, then you may all of a sudden realize through that, well, maybe I do want to take medications, or I do want to do those other things, right? And so partial services are sometimes very helpful because they may increase your ability or desire to then get additional services, especially when people are paying attention and listening to you.
Yeah, I totally agree with you, Beth, right? And when persons are empowered to be able to do that, right, and given that space, incredible things can happen, because persons also don't always know what's available. And that's one of the ways peer support can be very helpful too, is just having those conversations, talking through what an individual's choices are, what are they wanting out of their time at the organization, and helping to bridge some of those gaps possibly.
Oh, thanks, Amy. Thanks, Beth. So our next question is, Beth, what are the rights of people to make complaints or appeal, and how is that typically done?
So I guess there's several different ways, right? And so I guess the main ones that people are very familiar with is that if you are in a institution and you feel you're being abused or neglected, then you always have the right to make a complaint to HHSCPI, right, which is the Abuse and Neglect Hotline. for investigations. There's also, if you feel your rights are being violated, that you can make a complaint to the Behavioral Care Ombudsman, or potentially the CRO at a state hospital or a private psych hospital, and then also at the local authorities. And if they don't, if you don't like the results that they provide, then you can then boost that complaint up to the Behavioral Health Care Ombudsman over at state office. The other ones that I think people are not as aware of is if you have Medicaid and you're in the community and your services are denied, terminated, suspended, or reduced, then you are entitled to a fair hearing. And you are entitled to notice from the LMHA that says the reasons, the explicit reasons why they're denying your services or terminating or reducing or whatever else. And that if you decide you want to appeal and you do that within 10 days, that they have to keep providing you those services until the results of that appeal. Otherwise, you have 90 days to do that appeal. And that is a hearing where there's an independent hearing officer. You have the right to have somebody represent you at that hearing, and to explain why you don't think your services should have been denied or terminated. If you don't have Medicaid, you still have some appeal rights. They're not as formal, but there is a right to, that again, the local authority has to provide written notice to you, indicating the reasons why they are denying or your services. And you have 30 days to ask that that reason be reviewed. It has to be reviewed from a neutral person, not from the LMHA. The individual has to be provided an opportunity to express their opinion and concerns as to why it should not be reduced. And they can either do it by talking to somebody directly, they can do it in writing, on tape, or some other fashion. And then in both cases, the findings should be explained and provided to the person in writing, why those decisions are made. So I think those are kind of like a lot of the main areas that people can make complaints, and should receive actually written responses as to why, whatever findings are made in all of those cases.
Thanks, Beth. Amy?
Yeah, one of the things that I've seen over the years, especially around appealing, like when a person may have a abuse neglect report and it comes back unfounded, and that person has stepped out, they've tried, they've made this attempt, they have a feeling that something wasn't okay, and because of whatever, it was found unfounded. And like, what occurs for that individual is they stop trying, and then others see that person tried to do this and it was found unfounded, and they may have been involved in that circumstance. And I can tell you this over and over in my experiences as a patient at the hospital, as well as working in the community center. And it's not just abuse and neglect, but like clients' rights, it'll be like, why are you going to call the red phone? Nothing's going to happen, right? Or if you do, they're going to get you, right? The staff are going to like retaliate, even though it says they're not supposed to retaliate. There's that fear of retaliation. And, I don't know the full reason why this way of experience happens always for everybody. But I know for my own self, there was a lot of fear. I watched something occur myself and was involved in a circumstance. And years later, it came back that this person, it was unfounded. Years later, when I was working at the hospital, I asked my supervisor, who was the abuse and neglect liaison, and I said, I knew that happened, right? And we had a really honest conversation that was helpful to me in the sense of all the different things that have to be in place. And sometimes organizations know something happens and they can't do anything about it. I was always a big proponent too, to have people called Disability Rights Texas, especially if persons have a fear about going to anything internal at the organization. It didn't, it was always tell the information. They may or may not be able to help you, but they may be able to direct you. And for those people that had that fear of retaliation, that fear of getting less of services, or a number of things that can happen, don't always happen, right? But there's a fear. And I think the other thing that's in place is that people don't always know the channels, right? They don't know the fact that they can appeal if a finding comes back, as finding for whomever they made the complaint about. They don't know that even though there's a little bitty thing that says you can appeal, usually it's in like such a limited time that they don't make it. And then it's like, I hope that would answer the question. It's one
Yes.
of those things that I wish I had a really good answer. And there's so many different nuances as to the whys. And I think that's one of the things that happens with rights, is there's so many different nuances, and each individual who is in your program or the programs come in with their own worldview, their own baggage, their own experiences that add to a lot of times not speaking up.
I remember reviewing a case and working on a case where it was a child, and abuse and neglect, the fear factor, right? The abuse and neglect allegation got called in, and they went and they interviewed the individual, and the individual's like, no, I was not improperly restrained. I was not thrown down and almost choked to death, right? Which is what it was.
Mhm.
And it was only because there was a video by another kid on their cell phone that showed the whole thing, right? Like, it's like, and here's the kid himself saying, no, everything was fine, right? Clearly it was not fine. I mean, like, he was
Right.
literally being choked. I mean, it was very clear on the video. So it just shows that, there is that increased fear of reporting. And I think part of that too, especially when people are in institutions, right? Because as Amy indicated, that is the only people they know. There's no outside people. So you're reporting somebody who is going to be your caregiver, and you don't have the right to walk away from that caregiver. So that fear just increases tenfold.
Thank you for that. We're going to move to another area which has to do with client information and how it can be protected. I know this is a place where Amy is going to talk about the advanced directives, but we're going to start with Beth about confidentiality and protections under HIPAA.
Yeah, so both HIPAA and state law basically say that your mental health records are confidential. And I think Dr. Ziyad is going to talk about the few exceptions to that, but they are considered confidential. And but you are entitled to your own records, right? And a lot of times people ask for the records and they don't get them, and actually the laws are not followed. So what the laws actually say is that you are supposed to get your records within 15 days. If you do not get them within 15 days, you are supposed to be given a reason why there either is a delay and when they will be able to complete the request. Or if they've decided that they aren't going to give them to you at all, the only way they can do that is if they believe that your records, that there's a reasonable likely to endanger the life or physical safety of you or the other if you were to review those records, right? And that's the only way that they can refuse to provide them. And even in that situation, they can't refuse to provide all of them. They have to go through each one of your records and say, why this one would meet that criteria versus why the other one wouldn't. Because clearly your treatment plan can't, because you should be part of your treatment plan, right? So if you were part of your treatment plan and you signed it, you already know all of it. And so that should be a record that there would be no way that they could say would endanger you, right? Blood results or things like that again, right? So they would really have to go through each and every record to determine why you would meet that criteria. And then even in those situations, even if they decide that there are some, you have the right to then ask for an independent physician to determine whether or not that is an accurate determination. And they should provide all of this to somebody in writing when they are going to refuse those records. In addition, that notice should tell you how to file a complaint with the Department of Health and Human Services and with the Texas Medical Board. And then the other thing is that if you disagree with something that's written in your record, so you get your record and you're like, that is not true, I didn't say that, or I was not restrained on that day, you do actually have the ability to write like what would be considered a dissenting opinion, right? So you could write your recollection of what actually happened, and that has to be included in your file. And then I think the other big thing about it is if it's the individual themselves requesting their records, they cannot be refused their records just because they can't pay for it, right? So they can bill them, but an agency can bill them, but they still have to provide them their records. And the other piece too with that is HIPAA has a very low cost associated with what it would require to give you records, right? One, if it's electronically, it's like they can only charge like a couple of cents a page or something, and they can't charge like a retrieval fee or all these other kinds of fees. So it really still, even the charge itself, which should be de minimis. So those are ways I think that you can, go ahead and that you could get your records yourself.
Thank you, Beth, for reminding me. Dr. Nuwayhid, you're going to talk about those exceptions to the release of information records, and then we'll end with Amy.
Yes, so they're pretty brief. If there's some life-threatening situation or some severe medical or psychiatric situation, basically the emergency. Yes, I can sort of reach out to somebody, ask some questions, and say this is a situation. What's going on? That type of a thing for purposes of treatment. If somebody needs to know what's going on to facilitate treatment, both psychiatrically and medically, things like for public health reasons, that kind of thing can come up. That's typically not that they need to know what your mental health diagnosis is. For things like insurance payment, that type of thing, and sometimes for some data collection about hospitals or something. There are certain things with law enforcement or court things, but those typically will need more paperwork or a hearing. There'll be a subpoena, something like that, in order to get that information.
Thank you. Amy?
Sure. And this is where you may talk about the advanced directives, right? The
Absolutely.
conversation. Perfect. So, when we think about HIPAA, we think about our right to access protected health information. I think about over the years how so many people have challenges and have had challenges with maybe family members thinking they could have access to care when the individual actually would write, please don't let this person, they don't have, I'm not signing for them to have information. And I've seen family members be just like out of the blue, like, why is this? I'm their parent, I'm their father. And one of the things that I see about mental health advanced directives, and have used it in my own life, is it begins conversations, and they should be done when the person is well, right? And done in a place where you're able to look at, I use the one through Wellness Recovery Action Planning and have added a couple of different things because I really like that format. Beth, you have a really great one that maybe, I don't know if we can share documents or not, that persons can use. And for me, in my experience with having an advanced directive, it allowed me to really look at like what works and what doesn't, right? One of the medications that if I went to an ER really unwell, there's a certain medication they typically would put me on that really increases my desire to end my life, right? Because of whatever formulas are. So like I have it in there, and the reasoning why, please don't give me this one. And these have worked in the past, right? Because it helps us as human beings have a voice in a place where we typically have not had a voice. The place where we're experiencing, maybe hearing things, seeing things that others aren't, and are not able to communicate and have a lot of fear going on. But when we have our advanced directives, our voice is being able to be shared in a way that honors who we are and also lets the persons who are getting to know us maybe newly or seeing us in that moment, who we actually are. I like to write I have a paragraph about who I am, the work I do, all of those things. The other part about mental health advanced directives that I've used and seen is it also lets family members have a place, or friends, in like surrounding and creating a healing space where they felt very like they couldn't do anything in the past. And probably a number of years ago, 10, 15, I don't know, it's been a while, I got toxic on my medications and got really, really, really unwell, hearing things, seeing things, doing things that easily would have ended up in an institution. And because my supporters knew what to do, I had my cousin came and stay with me. I had persons who took care of the plants, mowed the yard so I didn't have to worry about it. We don't think about some of these things. Even though I was in my house, I had a friend who would come over and just make me laugh. They were not one that you could talk to. Like they were not a person who could listen to a whole bunch of stuff, but they had this way of being able to surround me as things, as I healed during that period of time, during that week, and had contact with my physicians and my therapists and my work, right? And in that, I was able to go back to work like a week and a week later. I wasn't institutionalized. I came out of it actually very empowered. We learned stuff about the fact that I was toxic on the medications because my cousin was a nurse and was noticing certain physical signs that I was having. And it was powerful. And I've seen advanced directives where a person has gone to a new institution or a new hospital when they've been able to like share it and give it, and then talk later about just how different that experience was. Because in times where they felt powerless, they had a sense of autonomy and a sense of empowerment. So the other point,
oh,
yeah,
I'm sorry, Amy, go ahead.
You're fine. I just don't want to be remiss and not say this.
Yeah.
The side effect, so to speak, of creating the mental health advanced directives was I had conversations I hadn't had with people because I was afraid, because I didn't want to talk about being unwell because they had gone through some of the really difficult times in my life. And they were like, well, I didn't know, like, I saw that, but I didn't know that. And it was a beautiful experience for me. And I've seen that be the same for others. So thank you.
Just a follow-up from a question from the chat. Some of our audience wants to know who can help with those advanced directives.
So for me, once again, I utilized and used kind of a format through Wellness Recovery Action Plan. Anyone can help and walk someone through the mental health advanced directives. As a peer supporter, I've supported a lot of people in filling them out and having conversations. And I personally had mine notarized. Beth may be able to talk a little bit more about some of the legality pieces as some of the things continue to change. But anyone can support an individual in creating those. Mostly people just don't know they exist. And the key for me is that organizations, if a person does have them, that they actually look at them. And sometimes things can't be honored, right? There may be certain thing, a certain request, but explain why it can't be honored. So.
Yeah, I think Trala actually does a couple of sessions where they actually work on helping people with advanced directives, but you can also again call Disability Rights Texas and we can assist in providing some help with filling out a psychiatric advanced directive. As Amy indicated, I think there is a sample form that is supposed to be part of the session that is pretty easy to fill out. I mean, it's pretty straightforward in terms of filling that out. And yes, I do think that, if somebody has filled out a psychiatric advanced directive, that it does need to be followed. I know Sonia is asked, if they say that that they want to be institutionalized, does that have to be followed? And actually, that is not part of the psychiatric advance directive form. It's not part of that at all. And the problem with that is that you have to be able to voluntarily agree when you get institutionalized, because, and there was a case on this called Zinnerman v. Birch, because the whole point was, if you're voluntarily put into an institution, you have to know your rights and be able to advocate for your rights to be able to leave if you wanted to leave. So if you don't have that capacity to truly understand that you're voluntarily there, then you also don't have the capacity to understand how to get yourself out. So that's the reason why that wouldn't apply in that situation.
Okay, thank you. That's I really appreciate that information. We are going to go on to some other questions in the chat. There were quite a few questions about medication in our Q&A. I'm going to start with this first question, which has to do with if a person is, say, lacks awareness or insight into their own mental illness, how can we expect that person to make good, rational decisions about living conditions, taking medications, and even right from wrong? Why aren't we mandating treatment and medications for such a person?
So just I'll start with that. The issue usually is that that person is not always unaware of what's going on or always making bad decisions. If somebody is in such bad shape that they're sort of never able to do that, it's probable that they will, get services and go through the system and be placed somewhere eventually. It might be a time-consuming process. The problem usually is that people get on and off their meds. People are sometimes more acutely symptomatic with whatever illness they may be suffering from. And, when do you catch that person? Are they doing better and they're able to be discharged? They can advocate for themselves. Treatment really can't be mandated. Or are they sort of on a downswing, and it can be, they do get committed, they do get medicated, but then they get better and they're able to sort of go back to the community at the level they were before. And that's typically the problem. So, and when somebody decompensates or gets off their meds or something like that happen, or maybe there's some kind of trauma occurs, some acute change in their life. And then but at that point, we're sort of starting from scratch with the whole, well, does this person really need to be forced to get treatment? Do medications need to be forced? And that assessment and that process has to begin again.
There's a question about whether or not, if a person is receiving housing supports, if they can be forced to go into substance use treatment.
So I actually don't know the answer to that, and I can find out to make sure.
Okay.
Now, they can't do that. I mean, so in terms of if it's just through the local MHA and the local MHA is providing those services, no. Again, right, with the local mental health authority, you have the right to choose what services you want, what services you don't want. And so you can choose to have housing without having substance abuse. Now, there might be some Section 8 differences that with Section 8 there may be, and that's the part that I'm not sure of. And so that's why I'm putting that caveat out there. But otherwise, you should be able to accept housing through the local mental health authority without accepting psychiatric medications, without accepting substance abuse treatment, or any of those other things. So they should be completely distinct. They shouldn't, unless you also should not be drug tested. The local mental health authority shouldn't require drug testing either for any treatment that you're receiving, unless they can explicitly show that one of the medications you're taking would have some significant adverse effect if you actually were taking some kind of drug or something. So, but that would be the only times.
And if I could just add something really fast, and the only time I've experienced that for myself is housing that was more privately run, where you were required to attend AA meetings or something like that in order to be at that house, versus some of the more publicly funded experiences. That's the only place I've experienced where it's been a requirement.
Well, thank you so much. And on that note, we're going to have to end. As we said at the beginning of the hour, if we don't have time to get to all the questions, and there were lots, we promise to get back with you if you put your name in the with the Q&A so that we can respond to you. Thank you so much for the panelists for all your valuable time and insight today, and to everyone that was able to join us today. When the forum ends, you'll be prompted to take a short survey. We hope you'll take a few minutes to share your opinion and how we're doing and what topics you're interested in for future forums. We know that there wasn't enough time today to get to all the questions or to really talk about this very important subject, but we are so glad that you all joined us. Thank you so much, panelists. Bye-bye.